It is now clear that the courts will use their powers to require litigants to engage in mediation. I want to touch briefly on the international perceptions to mediation as an international mediator.
Good afternoon to all of you. After the wonderful inaugural session, which has set the key for this particular program, now we have the first plenary session. The topic for this session is integrating mediation into everyday court practice. And in this session, we are blessed to have Honorable Mr. Justice J.K. Maheshwari, Judge of Supreme Court of India, to chair the session, and Honorable Justice Prashant Kumar Mishra, Judge Supreme Court of India, to co-chair the session. We have Honorable Mr. Justice P. Shyam Koshi, Judge High Court of Telangana, as one of the speakers and resource person. We have Miss Norma Alvarez, Senior Advocate and Padma Shri, as a resource person. We have Shri Apurva Kumar Sharma, Executive Chairman, Bar Council of India. And we have Shri Ved Prakash Sharma, Co-Chairman, Bar Council of India. So, without further delay, I request Shri Apurva Kumar Sharma, Sir, Executive Chairman, Bar Council of India, to kindly felicitate Honorable Justice J.K. Maheshwari, Judge, Supreme Court of India. I now request Shri Ved Prakash Sharma, Sir, Co-Chairman, Bar Council of India, to kindly felicitate Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India. I request Shri Bret Kumar Prakash Sharma, Sir, to kindly felicitate Honorable Justice P. Shyam Koshi, Judge, High Court of Telangana. I request Shri Apurva Kumar Sharma, Sir, Executive Chairman, Bar Council of India, to kindly felicitate Ms. Norma Alvarez, Senior Advocate and Padma Shri Awardee from High Court of Goa. With without any further delay, the theme of the session, as I said, is integrating mediation into everyday court practice, and the focus is on practical integration of mediation into our daily court proceeding, a crucial step in making mediation an integral part of justice delivery system, as it has been highlighted by the Honorable Chief Justice of India and the Honorable Judges of Supreme Court and the Chief Minister. So I request Shri Bred Prakash Sharma, Co-Chairman, Bar Council of India, to kindly deliver the welcome address.
Honorable Judges of the Supreme Court, Justice J.K. Maheshwari, Chair of this session, Justice Prashant Kumar Mishra, Co-Chair of this session, Honorable Judge of Telangana High Court, Justice P. Sam Koshi, Padma Awardee and Senior Advocate Ms. Norma Alvarez, International Mediator Mr. John Abbott, who has joined us online, Executive Chairman Bar Council of India Shri Apurva Kumar Sharma, distinguished delegates, learned faculty of ILR, members of the bar, mediation professionals, students, ladies and gentlemen. It's my proud privilege on behalf of the Bar Council of India and Bar Council of India Trust to extend a very warm welcome to each one of you to this national conference and symposium on mediation, which is being held in collaboration with India International University of Legal Education and Research here in the serene, picturesque state setting of Goa. We are deeply honored by the presence of the esteemed members of the higher judiciary, whose vision, wisdom, and constant engagement with justice delivery lend great depth and credibility to this symposium. Your presence itself is a powerful affirmation that mediation is no longer peripheral, it is central to the future of justice. Mediation, a word conspicuous by absence in our legal justice dispensation system about 20 years back, has become a buzzword today. It has added a new dimension to the justice delivery system by giving a living recognition to the right of self-determination. Thanks to the initiative and proactive approach of the Apex Court, a rich legal jurisprudence has developed around the subject. Today, we can say with confidence that mediation has graduated its position from an alternative to front seat acclaim in the justice delivery system. To add another feather in the crown of mediation movement in our great nation, Mediation Act 2023 may pave way for its wider reach. Journey of the last 2 decades has not been easy. We had to seek light where there was darkness all around. We had to travel on bumpy roads, and we had to build from the scratch, and we have done it. Friends, the theme of this session, integrating mediation in everyday court practice, touches the very heart of our justice system. Our modern justice system faces unprecedented challenges, mounting dockets, prolonged timelines, emotional and financial strains on litigants, and silent erosion of public faith caused by delay. My dear friends, we are about to bid farewell to the old year and welcome the dawn of the new year. This is the time to do an introspection and get rid of what is not good and to inculcate the best. I take this opportunity to mark certain concerns which I hope will see considerable deliberation along with other listed subjects of this conference. Number one, whether the legal ecosystem is prepared to give a launchpad to the pre-litigation mediation in the real sense of the word. Our experience with Section 12 capital A of the Commercial Court Act has been pathetic in this regard. The recourse to mediation has only been to get a non-starter report to be able to file a suit. Number 2, whether Section 44, subsection 4 of the Mediation Act 2023, which makes the settlement in a community mediation as unenforceable in a court, will run out to be a stumbling block in the wider penetration of mediation. 3, whether the corruption or fraud as a ground of challenge to a mediation settlement agreement as laid in Section 28 of the Mediation Act 2023 are too widely worded, and it may amount to taking with left hand what has been given with right hand. Are we opening another floodgate of litigation or replacing one kind of litigation with another kind of litigation? 4, whether we have answered the concerns of the other institutions which are deeply ingrained in our socio-economic fiber like panchayat, etc., which may feel threatened or face existential challenge. And 5, whether the training of mediation has remained static over the years or has been going hand in hand with the international best practices. These and other ancillary and incidental concerns will emerge in the course of deliberations here, and I hope that the conference will be able to draw a roadmap ahead for a robust system. Before parting, I want to share a couplet authored by an enlightened soul. न्याय के आंगन में जब बोझ बढ़ जाता है, संवाद का दीप तब राह दिखाता है। जंग फैसलों से लंबी चलती रहती है, सुलह से हर मन भी जीता जाता है। My dear friends, with these words, I once again extend a heartfelt welcome to our distinguished panelists, respected judges, and all participants. May today's deliberation help us move closer to a future where every courtroom carries within it quiet strength of mediation. Wishing you all a Merry Christmas and a very Happy New Year 2026. Thank you very much.
Thank you, sir, for your warm welcome words. Now, I request Ms. Norma Alvarez, Senior Advocate from Goa and Padma Shri, to kindly share her thoughts on the topic.
Respected judges, lawyers, students, friends, I have always been a passionate advocate for resolution of legal conflict outside the courtroom, especially when the conflicts involve family members or neighbors. I remember when the Lok Adalat system commenced in Goa about 2 decades ago, I routinely sat on those benches and was amazed at the number of matters. At that time, I remember mostly claims, accident claims compensation matters that we were able to settle just applying a little persuasion on both sides, asking the government, give a little more, asking the party, if you go back to the court, it will take so long for you to settle it. I therefore see mediation as an essential pillar of the access to justice system. It is a space where people are heard, respected, and encouraged to find solutions. From a woman's perspective, mediation is particularly important because many legal disputes, matrimonial, family, workplace conflicts, and inheritance matters do not affect us women merely on paper. They are not merely theoretical issues. They affect our safety, our children, our dignity, our relationships, and our future. In short, they carry an emotional and social consequence that goes far beyond the courtroom. Traditional litigation, as we all know, is slow, expensive, and emotionally exhausting. It often turns simple disagreements into battles. Whereas, as the judges said in the morning, one side must lose for the other side to win. But mediation offers something different. It gives women a voice. It allows us to speak for ourselves rather than through aggressive legal strategies that may silence or intimidate us, or even sometimes embarrass us, because what we hear the lawyer saying on our behalf is really not what we wanted to say to the other side. Another important factor that women have to contend with in any dispute is power, the exercise of power. Who exercises power? In our patriarchal society, power invariably rests with the male, the husband, the in-laws, the boss, sometimes even the judges. Do they understand what a woman is going through to pluck up the courage to bring this dispute into the fore for resolution? But in mediation, power imbalances are attended to, and an effort is made to create a level playing field through dialogue. A woman speaks her mind, and the mediator sorts out and tries to give everyone a level playing field. And in the end, because the outcomes are shaped by consent rather than by diktat, rather than by a judgment, it enables women to live with them. Women look for solutions that are practical, that are restorative, that are sustainable, especially in matters where the relationship must continue. For women, therefore, mediation not only means quicker resolution of disputes and reduced trauma, but outcomes that enable us to move forward with dignity. And in a world where women are still striving for equal access to justice, mediation comes as a tool of empowerment. It reminds us that law can be compassionate and that justice can be delivered without destructive ends. Finally, in the Indian context, where courts are overburdened and delayed justice is denial of justice, mediation provides some respite to the judiciary itself. In fact, it strengthens the justice system, it reduces pendency cases, and it upholds fairness and autonomy. Mediation, as the judges said, is neither a sign of weakness nor a sign of compromise, nor is it inferior, nor is it a second-rate form of justice. In fact, instead, it is a symbol of wisdom and hope for the future. I therefore am very pleased and happy that the judges of our Supreme Court have come down to this forum to endorse and promote and dignify the concept of mediation. Thank you.
Thank you, ma'am, for your wonderful deliberations on this important subject. Now I request Honorable Justice P. Shyam Koshi, Judge, High Court of Telangana, to kindly deliver his address, sir.
A warm good afternoon to one and all in the auditorium. Honorable the Chair of the session, Honorable Justice J.K. Maheshwari, the Co-Chair, Honorable Justice Prashant Kumar Mishra, both of whom hail from the state from where I am, the Co-Chairman, Bar Council of India, Shri Ved Prakash Sharma, Mrs. Norma Alvarez, panelist on the dais, Shri Apurv Sharma, again a panelist on the dais. At the outset, may I express my deepest gratitude to the organizers for having given me this opportunity to stand before this august gathering and to express a few words on this topic on mediation. And I also feel blessed to have the occasion of sharing the dais with Honorable Justice J.K. Maheshwari and Honorable Justice Prashant Kumar Mishra. The topic for the session is integrating mediation into everyday courtroom practices. We have heard a host of speakers initially at the inaugural session and the two distinguished speakers in this plenary session. And what has been culled out is that mediation in today's world has become the necessity. It is, in fact, the need of the hour. The need of the hour, as has been rightly put by Mrs. Norma, for the reason that it will ultimately give respite to the judiciary. Respite to the judiciary, firstly by reducing the pendency of the huge dockets that are pending before every court across the country. Two, because it will also curtail a great amount of filing of the cases if it can be resolved at the threshold before the parties take it to the litigation. What do we do to make it happen in the everyday court practice? And which, as on date, today seems to be a daunting task. In my personal opinion, what is required is taking a clue from what Honorable Justice Maheshwari said in his inaugural address in the morning. This needs to be made the first recourse to disputing parties, rather than knocking the door of the court of justice and then thereafter being referred and then subjecting to mediation and falling back to litigation. Let this be made the first recourse for any person who has some dispute with any of the parties of any nature. Another suggestion that I have is, now that we have amended CPC and introduced section 89 dealing with alternate dispute redressal mechanism. Earlier times we used to have section 80, which is still there, giving a notice before filing of any of the suits against any of the government body and government. Why can't we have such a mechanism or a provision in the CPC itself that this be made mandatory for every litigant to explore the possibility of mediation before he approaches the court by way of either a suit or a petition or a case or a original application or whichever forum that he intends to go, be it consumer forum, be it motor vehicles tribunal or any such forum that he knocks. Let there be a mechanism where, or a platform where he has a recourse of mediation explored first, and only on the failure of the mediation should the person concerned be sent to litigate his matter before the concerned court. As judges and members of the legal fraternity, we are entrusted with safeguarding fairness, efficiency, and the public confidence in the justice system. Courts across the country are increasingly burdened by growing caseloads, procedural delays, high litigation cost, and the adversarial processes that often intensifies the conflict further rather than resolving it. Traditional court adjudication mechanism, while essential for determining legal rights and setting precedents, is not always the most effective means of resolving every dispute. It is in this context that mediation and the mechanism for mediation and the platform for mediation becomes the most urgently need forum as on date, and has to be treated as one of the most vital alternate dispute resolution mechanism. In that broader role, mediation is not simply a case management option. It is a strategic judicial recourse, one that even integrated thoughtfully strengthens the court's capacity to deliver justice in a sustainable and credible manner. Today, as we strive forward with this two-day conference on mediation, we need to understand that mediation is not the alternate to justice. It has to be, as has been stated earlier also, to be treated as the primary recourse, not an alternate recourse. Today, at the core of the discussion, mediation is a structured, voluntary process in which the parties, the disputing parties, communicate identity and identify interests and explore the solutions. Unlike litigation, mediation focuses not only on the legal rights but also tries to maintain the relationship between the parties, the future needs between the two parties, and the practical outcomes where the interest of both the parties stands secured. We need to take this forward from where we are standing today. Today we were told that there was a gathering of around 1,000 plus delegates across the country. This 1,000 plus candidates need to take it further, manifold, so that the terminology mediation itself, the mechanism of mediation is taken down to the grassroots level. Today when we speak of mediation, Frankly speaking, when we are sitting at the headquarter level or the high court level, it seems that mediation is fast catching up. But the hard reality is the moment you enter to one of the remote districts, the district where the access is a bit difficult from the mainland, mediation is something totally alien to the agency. None of that citizens in that remote village may be in a position to know what mediation is, to know whether mediation is also one of the ways of trying to resolve a dispute in the society where he is living. This makes mediation especially valuable in everyday court cases, family disputes, small claims, neighborhood conflicts, employment matters, and even certain criminal cases which may be of petty nature, and also matters or disputes pertaining to the administrative cases. Mediation is a structured and flexible process in which an impartial and neutral agency or the party mediates between the rival groups, assisting the disputing parties to communicate, identify, underline the interest of both the parties so that they can mutually explore what is acceptable and what is not acceptable and reach to an amicable solution. Mediation, as we all know, ultimately is not imposing upon someone an interest of one party alone. It is instead an outcome shaped by the deliberation between the parties and where each of the parties acknowledge the right that is there for each of the parties, and where by way of the amicable solution they can resolve the dispute and which can lead to a win-win situation. Another aspect which we need to know is that mediation, as we all know, being need of the hour, there has to be an awareness campaign that needs to be taken across the country to the nook and corners where people are made to know that even without knocking the doors of the courts of justice, you can avail a mechanism by which disputes of any range can be resolved. How do we have this campaign? And it is there that members of the legal fraternity have a crucial role. Every member who hails from the respective place from where he comes from needs to carry this message that they are, in addition to being a lawyer, also trained and well equipped in the art of mediation, where a party who approaches them with any sort of a dispute, may be of petty nature at times, may be where the core issue being quite simple, is resolved by way of mediation, and where people also know that without even approaching the courts, their dispute can be resolved in the best possible manner. And how do we take it further down? And it is there where my opinion is that this subject of mediation has to be made part of the curriculum from the schools, colleges, universities, everywhere where people as on date take it for granted that other than going to the court of law, their interests cannot be protected or they do not have another forum or a platform where the dispute that they have can be redressed. Once if the subject mediation becomes part of the schools, colleges and universities, it will go to every household in the country, and people across the country would be mediation, the forum of mediation, the platform of mediation would be availed and would be utilized for the betterment of the justice delivery system in the country. Thank you so much.
Thank you, Your Lordship. Now I request Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, to kindly address the gathering. Sir.
My esteemed brother, Justice J.K. Maheshwari, Judge, Supreme Court of India, and Chairman, Supreme Court Legal Services Committee, Brother Justice P. Sam Kosi, Senior Judge, Telangana High Court, Mr. Apurva Sarma, the Vice Chairman of BCI, Mr. Ved Prakash Sarma, he is probably co-chairman of BCI, and Ms. Norma Alvarez, the legendary advocate of Goa, and with profound gratitude and humility I stand before you today for sharing with you my views in this plenary session on integrating mediation in everyday court practice, which is a part of the Bar Council of India and Bar Council of India Trust Poll, first in collaboration with India International University of Legal University and Research, Goa, here. Today, we have taken pledge in the morning, and the first of this pledge is to commit to choosing mediation first, promoting dialogue over dispute, understanding over accusation, and healing over hostility. This particular pledge encompasses within it the whole theme, culture, and the object of mediation as a tool to overcome the customary litigation. It is not only to overcome litigation, as we always see, it is to heal in contrast with hostility and develop understanding over accusation, to give a lasting peace to the warring parties and to provide for them a stage, a platform where they can solve their dispute like which was tried centuries or decades, or rather eras of hostility, when during Mahabharata and Ramayana. We always give example as to how mediation was tried in Mahabharata as well as in Ramayana. But I always say that the failed mediation in Mahabharata teaches us the biggest lesson as to what happens when you fail in mediation. It is not that while saying so, I am discouraging that mediation should not be tried, but I am calling upon all stakeholders to see that mediation, once chosen as a tool, as a way, and as the process to resolve the litigation, we must see that the mediation is fructified. It reaches to its logical end by making the parties to resolve their dispute, making them to understand. Alternative dispute resolution is often seen as the alternative to litigation. It involves mediation, arbitration, negotiation, conciliation, and lok adalats. When we talk about mediation in particular, it involves a structured negotiation wherein an independent person tries to bring the warring parties on some middle ground. The process of mediation is completely voluntary. Neither parties nor the courts can force the parties to undergo mediation. Hence, mediation is nothing but uniting the parties. It saves precious time and energy and litigation costs apart from saving them from prolonged litigation. In mediation, the parties can directly communicate with each other across the table. Since the process of mediation is voluntary, the parties can adopt a flexible approach and reach an amicable settlement. Courts today grapple with over 51 million pending cases nationwide, supported by only about 21 judges per million population, far below 50 as recommended by the Law Commission. This situation thus calls for urgent and radical measures. Mediation can certainly be an effective means in reducing the docket of cases across the country. However, there needs to be a shift from traditional to modern methods in ensuring that mediation gets emboldened in a legal system of India and becomes a part of everyday court practice. I would like to share with you the ways in which this transformation can take place. First amongst those is the strengthening of pre-litigation mediation system in India. Pre-litigation mediation refers to a voluntary and consensuous mechanism through which parties to a dispute engage in an amicable settlement process with the assistance of a neutral third party prior to formal institution. The scope of pre-litigation mediation is broad and encompasses a variety of disputes, including family and matrimonial matters. To assess the importance of pre-litigation mediation, observations made in the case of Srinivas Rao versus Deepa, 2013 Supreme Court, can be looked into. This was a matrimonial dispute where the Supreme Court opined that if in this case during the initial stages the matter was referred to mediation center or pre-litigation clinic, the animosity would not have grown. Thus, in many cases where there is a little miscommunication between the parties, the same can be resolved through pre-litigation mediation mechanism. Capacity building for peace building. Capacity building, as we understand and we have been talking since morning, is one of the foremost requirement in this mission of mediation as an alternative dispute resolution. It is central to ensuring that mediation, particularly peace-oriented mediation, becomes not merely an aspirational goal but also a workable reality. A robust capacity building framework will encourage individuals and institutions with the ability to identify emerging conflicts, select appropriate resolution strategies, and address dispute constructively. Equally important, it enables stakeholders to anticipate and prevent future conflict by fostering dialogue, understanding, and collaborative problem solving. In the inaugural session, Honorable the Chief Justice of India was informing us that today we have a force of 39,000 trained mediators, but actually we need more than 2 lakhs. That means almost we are 1/6 of the total need of mediators. We have to go a long way to make this exercise of capacity building a realistic goal in near future. But as we know, recently in Bhubaneswar, there was a conference on mediation organized by the government of Orissa and the Ministry of Law and Justice, central government. And back to back now this event is happening. That shows a trend that all the stakeholders, BCI, the concerned Ministry of the central government and all, they have taken this mediation mission as a path in way of fulfilling and strengthening the whole idea of access to justice. Unless we improve the access to justice tool in achieving the real goal of securing justice for all concerned, we will not succeed in our mission. And the role of Supreme Court of India in capacity building is really very commendable, and Supreme Court is striving hard under the able leadership of Honorable CGI and Honorable Justice Maheshwari and Justice Vikram Nath to see that we have a proper workforce to deal with this mediation. Role of referral judges is also very important, because what happens, at the initial stage of a litigation, the parties are shy of demonstrating or making the other party or the other lawyer or his own lawyer feel that I am somewhere weak in the litigation. To hide their weakness, they demonstrate that no, I am not going for mediation. Because otherwise the other party will feel that he has a weak case and he will not agree for mediation and the litigation will continue. But when the suggestion comes from court, then it is easier for the parties to shun their shyness and agree for a mediation, so that the mediation progresses well and it hurts none, either of the parties. Then comes involvement of technology into the mediation sector. But this is a very, very nascent stage, how to involve technology in mediation. We are in fact involving in Supreme Court, whenever we recommend for mediation, we are allowing parties to participate in the mediation process through virtual mode. That is one way of looking at it, but that is a long way to go. Then there is another aspect of favorable legal environment. How to create a favorable legal environment for promoting a settlement culture between the parties. The another facet of this mediation mission is to encourage public awareness from a mindset of conflict to a mindset of coexistence. And we were just discussing with Brother Justice Maheshwari that community mediation is one such area where we should need focus. May probably Justice Maheshwari will throw more light on this community mediation aspect. Now towards the end, I wish to emphasize that mediation is not merely an alternative to litigation, it's a transitional philosophy of justice. It is a mechanism which further strengthens the belief that legal challenges can be resolved with dialogue and deliberation. Mediation also resonates with the philosophical understanding of justice, where justice is not confined to procedural correctness, but is measured by its real impact on human lives, dignity, and social harmony. In enabling dialogue, restoring agency to disputing parties, and reducing injustice in practical terms, mediation brings justice closer to the people it is meant to serve. I commend the Bar Council of India, the Bar Council of India Trust Paul First, and the India International University of Legal Education and Research, Goa, for providing this important platform for reflection and dialogue, and confident that deliberations of this conference will contribute meaningfully to strengthening mediation as a central pillar of justice delivery in our country, and God willing we will succeed. Thank you so much.
Thank you, Your Lordship, for your erudite views. Now I request Honorable Justice, Mr. Justice J.K. Maheshwari, Judge, Supreme Court of India, and Chair of our session, to deliver the address.
Good afternoon. I will not address individually. I will say the person sitting on the dais of the dais. First question in my mind. Don't worry, I will not bore everyone. I will put one question. Why integration of mediation in everyday court practice necessary? You know? I can answer from the example of today. In an inaugural session, we have seen 800 persons are here. But in this session, we are seeing how much? Only 10%. And suppose we integrate it in everyday court practice, the result would be, I can tell you, 40%. Remember this in your mind. So I will start from this. Now I say why it is necessary. If we see preamble of the Constitution, justice, social, economic, so and so, so and so. I say justice preceded with liberty, equality and fraternity. So make it a point why it is necessary in everyday court practice. Otherwise, the day in court for many has become a decade in court. And we have to remove this, how we can. Now, I can tell something. I know my preceding speaker said everything about everything. I have some different points. What is the necessity of the mediation? This is a Sanskrit couplet. Sambada samadhanam satrunamapi bandhutvam. Dialects transforms even adversaries into allies. Now mediation, what it is? Mediator is a neutral man. He knows what A's problem, what B's defense, and if that will go hand to hand, and he suggests something, you are right to this, you are right to this. If we see in India, though we go and suggest, no, you do this, this is right, this is right. This is not a part of the mediation. If we see, look into the foreign experts' view. But with the Indian culture, with the mindset, it feels to be necessary, go by this, and finally identify what should be the output if you will not go for devastation. I have already said, Mishra ji said, Mahabharata, everything. We are not saying for that. Now coming to the topic, why, how it can be integrated in court practice. We should not ask in a court, I am coming with all practical aspects. We should not ask by the court, should not ask, parties are ready for trial. We should not ask this. We should start with, has this considered by a mediation? If it is no, identify. We have to identify whether this dispute is identifiable by way of mediation, encouragement by our side and the members of the bar. Alignment must be with a timeline. It gives party autonomy. We have to identify party autonomy you have and clear referral pathway. Judgment you can pronounce, you can resolve, you can pass a judgment, but you prefer a resolution first. Go, if you can do it. Now I will go for some Mediation Act, some provision of Mediation Act 23. It preferred pre-litigation mediation, section 5, confidentiality, section 22, enforceability of settlements, section 27, and ODR, online mediation. Suppose we go for all this pre-litigation mediation. I will put an example, not go for the history. Then pre-institution mediation litigation started from Salem Bar, came to AFCON, then judgment, then it came to directly to Patel Automation. In Patel Automation para 48, the Supreme Court said section 12A cannot be described as a mere procedural law exhausting pre-institution mediation by the plaintiff with all the benefits that may occur to the parties, and more importantly the justice delivery system as a whole would make a section 12A not merely a procedural provision. Then the Supreme Court at the last said that we however make this declaration effective from 28-22. So this is made, then the issue arose, what would be the prior situation? I will explain one thing, why this Patel Automation came. The commercial litigation was there, section 711 was filed. Okay, this suit cannot be maintained for the reason that the Commercial Courts Act provides section 12A. The question arose, can it be? I am thinking in a reverse way, or a Supreme Court view and High Court view. Why I am saying this? High Court said you do one thing, section 711, then keep it pending, go for mediation. But High Court, observations came, it should be a mandatory. Then what should be done? Mandatory means suit dismiss, withdraw, go for. Then thereafter Dhanwad came. Dhanwad clarified the 22-8-22 situation, what would be the prior and post litigation. And still one thing in my mind, as in the inaugural session I pointed out, whether everybody knows for a commercial litigation, first we should file a case before the State Legal Services Authority. Then as per the who would be the notified court under the Mediation Act, and as per the Commercial Court Act, it would be the Legal Services Authority. Otherwise you have to ask for injunction. 4 judgment I have seen. All 4 judgment, I recently visited to Amravati in Judicial Academy on the subject. He is sitting, one of the judge of the, I discussed this. And I would not say 3 judgment in one consonance, and the recent judgment 30th October, it goes something different. So I say always, it's a point left in a situation where the interim prayer is made in a suit, not for granting, but what is to be considered when a litigation is coming, which is a commercial litigation in the context of section 12A, and interim prayer is there and should ought to be maintained in a commercial court. So I was discussing this and giving the analysis of that. Still, there is a scope where we should go, where we should not go. We are not here to criticize here. We are here only to analyze the situations and go ahead, find out a further ways as much as possible which we can, because we have to promote the mediation. Now I am coming what we have to do. When we go in mediation in everyday practice, we are discussing pre-institution mediation. Now coming to section CPC, I find thin line differences in both. If we think about the CPC provisions, then for the purpose of what would be the status between the parties, Mediation Act says there would be a decree of the court, but otherwise here when we come to 89, it is a contract between a conciliation and deciding something. Suppose we go for enforceability, it's a thin line difference, because finally if we will not achieve, what we will achieve? We will not achieve anything. Then for enforceability, in a case where there is a mediation by Mediation Act, direct execution, and mediation is done, execution. And when you go to 89, then on the basis of that contract you have to go and file a suit. So this is a difference. These are certain, I am saying, where is the bottlenecks and how we can eradicate these. Then suppose we see the ground of challenge, what are? Go to Mediation Act, it is fraud, corruption and impersonation. And if we go to this 89, then whatever the defenses are available under the Contract Act, you can take all defenses. And suppose we go for the finality, the very limited ground for challenge were there. My time is over, sir. My time is going to be over. So then suppose finality in Mediation Act, I have meant go by watch always. So very limited grounds for challenge are there, but it can be reopened in the suit and it can be done. Now I am coming on the point, certain why it is necessary. I am coming pre-institution mediation. I will put an example. In Madhya Pradesh, there is a tradition in the tribal community. It is known as Bhagoria. Bhagoria means bhag jana. What happens to young boys and girls when they are in love? They leave. At the time of Holi, this tribal community do have this as a festive. And they call those both, they come, they sit, they settle. They say the main persons of the village of that or the organizers sit there, they say, all right, you have done this, but now the boy has to pay for the girl for this purpose or their family. And if it is settled there, then everything is specified, even child and everything, whatever it is, child, they were not of marriageable age. But if it is not settled, then it will go in the court of law, criminal complaint would be filed, and you will see the evidence. I have seen that evidence. The evidence you cannot imagine. It is so tutored evidence. 1, 2, 3, and you have to convict, no other option. So you see the devastation which we are discussing of the Mahabharata Yuddha, you see in present days also. Another, I think some of the people who have visited Lachun Lachen in Sikkim. It is an area where snow is there, and that is the Kanchenjunga series you will find there. You know, when I was as Chief Justice of Sikkim, I visited once. I find, where is the court? Find a answer. Here, sir, no dispute. Here, every dispute is here and being resolved by these persons who were the Panchaj who came to me for felicitate. They came and they felicitated. So this was a situation. I found how you resolve this dispute. Then they say, we find there is a family dispute, go in this way. There is a dispute of some business, go in this way. But we have no litigation. And this is a litigation zero court villages. I was very much impressed. And we have to find out there is no court here. So return back, Chief Justice, you have no place, go and return back from this place. So we return back. But these two things, and what we are discussing, fine, I am now putting an example. Recently in June 2025, Indore started community mediation. And this community mediation, about 5,000 cases have been decided recently after June by this time. What they are doing is, community based, we have provided a platform at collectorate and commissionariat. They are sitting, those persons of that community sitting, finding out what are the disputes of this community peoples, resolving that. So this is one of that. Though our permanent Lok Adalat are also doing something, mediation if you do with the government agencies not doing, then they are passing the orders also. So now these are certain points. So we have to think it, that how we can insert this in a routine court practice. So this is our topic. We will not go, time is short. Now I have to say in last something. Mediation is not a sideline exercise. It is central to justice delivery system. As I started from the preamble, what we have to do, proceeded with equity, fraternity. So I say in a different way, I thought as a chairman Supreme Court Legal Services Committee, what better we can do for this side? And this is a topic which has given to us for doing something. So we are thinking. So I say, it is central to justice delivery in India when systematically integrated into everyday court practice. If we insert this mediation, then we can ease court burden, promote reconciliation, preserve relationship, and deliver justice in a human approach, efficient and affordable manner. Friends, litigation gives a result, but mediation gives a resolution. And resolution is always better. It's a win-win situation for everyone. As a custodians, either of the judges or the members of the bar or the justice delivery system, our role is to champion mediation just not as an option but as a priority process wherever the law and facts permit. I am saying giving an exception permits. Please kindly thank you for my attention and reaffirm our shared commitment of a justice. We have taken a pledge. Please, shared commitment. It's a commitment to yourself. We are not saying to anyone. Shared commitment to a justice system that is not measured merely by judgment issued, but by conflicts resolved and relationship restored. Thank you. Thank you for all organizers to bringing me here and to give this opportunity to share my views. Hope now this has been increased. Accordingly, this percentage will increase. I hope, with this hope, I am leaving. Thank you.
So thank you, Your Lordship, for your wonderful and inspiring words. Now I request Shri Apurva Kumar Sharma, Executive Chairman, Bar Council of India, to kindly propose the vote of thanks.
Good afternoon to all. Honorable Justice J.K. Maheshwari, Judge, Supreme Court of India, Chairperson of this session, Honorable Justice Prashant Kumar Mishra, Judge, Supreme Court of India, the co-chair of this session, Honorable Justice P. Shyam Kochi, Judge, High Court of Telangana, Ms. Norma Alvarez, Senior Advocate and Padma Shri Award, whom today we have again felicitated, where our Honorable Chief CM was here, Mr. Vedprakash Sharma, Co-Chairman, Bar Council of India, other Honorable Judges from different High Court, other Chairman and Member from different Bar Council. We have seen from Kerala to Assam and Punjab. Yes, all are there now. Other Honorable Members from different High Court, young students, ladies and gentlemen. I consider it a privilege to propose the vote of thanks at the conclusion of this highly enriching plenary session on integrating mediation into everyday court practice. The deliberations today have been exceptionally engaging, positioning the vital and evolving role of mediation in strengthening our justice delivery system. At the outset, I extend my deepest gratitude to our esteemed chair of the session, Honorable Justice J.K. Maheshwari, Judge, Supreme Court of India, for graciously sharing this plenary and for his advancement, guidance, judicial wisdom and visionary leadership, which significantly enriched these discussions. I also convey my sincere thanks to Honorable Justice Prashant Kumar Mishra, Judge, Supreme Court of India, the co-chair of this session, for his incisive observations and for lending immense stature and depth to today's proceedings. I am grateful to Honorable Justice P. Shyam Kochi, High Court of Telangana, for his thoughtful contribution and for sharing valuable perspectives from the High Court of Judiciary on the practical integration of the mediation. Some of the members were not there when Lordship was delivered the lecture because of time constraint. As the chairman of the Executive Committee of the Bar Council of India, I extend my sincere appreciation to the BCI officers and staff, under the able dynamic leadership of Sri Manan Kumar Mishra, Chairman Bar Council of India and Honorable Member Parliament Rajya Sabha, for their resolve to the promotion of mediation and alternate dispute resolutions mechanism across the country. My appreciation also extends to the entire team of BCI Trust World First, without whose support and vision this program would have remained incomplete. I would like to acknowledge Mr. Vedprakash Sharma, Co-Chairman Bar Council of India, for his welcome and support in furthering the objectives of the BCI. My all esteemed colleagues from BCI, they are here, they are busy with all the other preparations. I would like to express my gratitude to Professor Dr. R. Venkata Rao, Vice Chancellor of this university, for his academic leadership and institutional support, which played a crucial role in the successful conduct of this program. I also place on record my sincere thanks to Ms. Norma Alvarez, Senior Advocate from Goa and Padma Shri Award, for her inspiring presence and valuable insights, and to Mr. John Abbott, International Mediator from London, who joined us online and enriched the session with a comparative and global perspective on mediation practices. I think most of them have all seen his videograph. Finally, I thank the faculty members, the BCI staff and ULAR staff, organizers, students, and all participants for their active engagement, insightful questions, and enthusiastic participation, which truly made the plenary session meaningful and impactful. Once again, I thank all the dignitaries and participants for their presence and evaluating contribution. For the session convener, Professor Dr. Anirban Chakraborty, my deepest appreciation, and to all ULAR volunteers, my special token of gratitude. May the learnings from this conference continue to guide us on the board and resolutions. Ending with a reflection on mediation as an intimate human characteristic, I wish to end by sharing lines from one of of the songs from Dr. Bhupen, that Bharat Ratna Dr. Bhupen Hazarika. He is saying that Ami Ekekhon Naware Jatri. Ami Ekekhon Naware Jatri means we are in the same boat, brother. So once again, I congratulate you for attending this function and also wish you happy New Year 2026. Thank you in advance.
Thank you, sir. This concludes our session. So after this, we break for lunch for about 15 minutes. And the post-lunch sessions will be in parallel. So the training sessions, those who have registered, training sessions will be in the designated room numbers. Please ask the volunteers, they will tell you. Moot Court Hall will be one place where maximum training session volunteers, maximum trainees will be there. The panel discussion one will be again in this particular venue only, and the paper presentation will be in room number 4. So volunteers will be there to help you. So please, feel free to inquire with them. Thank you very much.
Yes. Good. Wow.
Everyone, please note the room numbers for the scheduled post the lunch, which will be for a duration of 15 minutes. We will be having training session 1, which will happen in room number 12 on the first floor. Training session 2, which will be in room number 13 on the first floor. Panel discussion 1, which will take place in the Moot Court Hall. And the paper presentation in room number 4 on the second floor.